Good morning, Ilza. I see you put a message up about getting slides. Yes, we'll share the slides at the end, or at least the day after or so. Yes, Karen, all the attendees are muted, so only the panelists have the ability to speak. All the others are automatically muted, but you're welcome to put questions in the Q&A. I will answer those on the fly as we go along. And we will also collate them at the end, so we'll share all the Q&A with everybody, Karen. But welcome. Morning, Mercedes. Morning, Sandy. Hello, Sarah. Karina. Morning. It is still morning. 7 minutes still to go. Then it's afternoon. Hi, Elvira. Hi, Sharon. Hi, Letitia. Really curious where all these meetings come from. It's so nice with these webinars that they could be from virtually anywhere in the world for that matter. Hello, Adele. Slanta, how's it? Morning, Vanessa. Hello, Sandy. From East London, there's someone saying where they're from. Say where you're from, then we can at least get an idea of where we're all touching base. Those of you that are saying good morning. There, Northwest. There's Letitia, Grit, Brockrivier, George. Hello, Maritza. Marguerite, Northcliffe, round the corner from where I'm sitting. Michaela, Middelburg, Stellenbosch, Cape Town. Oh, this is fun. This is exciting. Polokwane, Josie, Stellies. Hi, Christiana. There's Pretoria. Parkmore. Hello, Maria. Clarksdorp. How's it, Judy? Lepalale. Oh, this is nice to see. Oh, and they're rolling in. There was Botswana. Fantastic. Tukai, my old stomping ground. Durbs, Kyalami, Bolu. There's Geberga. How's it, Catherine? Parijs, welkom. Hi, Santon. Durbs. Nelspruit, Mbombela, Cape Town, Westville. Oh man, this is really nice to see. Nice mixed bag of South Africa. There, Geberga, how's it? Hi, Sonia. There's Belito. Gosh, I think we've got a really good cross section here from all over South Africa. That's really wonderful. Where are you from, Estelle? Cape Town, Arties. Good morning, everyone. It's 11:56. The webinar is scheduled to start at 12. We'll give everyone a little bit of time to trickle into the virtual room. So we'll start off formally around about a minute or two past 12. But in the meantime, welcome. Yes, there's Shanice Chetty. You're asking there whether we'll distribute the material. Yes, so I will confirm that in my introduction, but I'll say that anyway. We will share the presentation with everybody as well as the Q&A so that we can at least all have that afterwards. So, but I'll confirm that as well in the introduction once everyone's here. There's Eswatini. Hi, Zinhle. It's London, Paul. I think that's, hello, Lydia. You're the first one in here from Paul. Van Bale Park. Hi, Christina. Mondio, Joburg, Dumasani. Good morning. Banana Airlines. Hello, Esther. All people from Josie, Randburg, Mohammed from Josie. Vrystaat. Durbs. Rosebank. I don't know if that's Rosebank, Cape Town or Rosebank, Joburg. Okay, time check 11:59. We'll give everybody just a minute or two still. Morning, East London. Hello, Daniel. Where are you from? Oh, there's Basson. Hello, Basson. You know, I've met many a time. Hi, Daniel. Pretoria, also my old stomping ground. Koelsberg. Wonderful. Hi, Karen. Swellendam. Oh, lovely. Hi, Swellendam. Maret. Okay, it's 12 o'clock. We're going to give one more minute and then we will start. Insurance-wise, Bloemfontein. Hi, Veronica. Hi, Leanne. Nice to see your name. You well? Glad Cape Town is sunny. Enjoy it while it lasts. Okay, we'll start in a minute. Sheppies. Right, I'm going to start formally now. Thanks everyone for all the pleasant hellos and the good mornings there on the chat. It was actually quite heartwarming for me to see everyone from all over the country. It's really, really special. So thanks for sharing that. It was really, really nice. Thank you very much. I see more people coming in, but we're going to kick off now. Welcome and thank you for joining us today at this webinar. We've got a lot to get through in a pretty short space of time. So we're going to keep it punctual and we'll get straight onto it while the others are still joining the room. So morning to those that are still coming in, but I've started now already. My name is George Findlay. I'm from LexisNexis. I'm the head of the corporate sales here, and I'll be facilitating today's session. And this is the second webinar in a series that we're focusing on FIC, Financial Intelligence Center, and KYC, which is Know Your Client. This series is designed to keep you updated in a flash with the critical content that you need to know. And I must say, it's actually quite remarkable. I mean, what we aim to do is to keep you or your customers off the FIC naughty list. And it's kind of daunting if one thinks about it, that in November 22, there were some big legislative changes that were published. Then even more bulletins were published earlier this year. And just recently, the General Law Amendment Act brought some changes again. And all of these changes lead us almost that we have to learn a new language. I was speaking to Milani earlier, and it's almost a new language with all the abbreviations and a whole new knowledge base that we've got to get to grips of. And we also have all these new accountable institutions. In the past, it was just the financial institutions and the attorneys and the estate agents, but now it's also the money lenders, the cryptocurrency industry. In fact, anyone who sells high-value goods is actually subject to all these changes. So there's a lot to unpack. And to learn this new language and this new way of thinking and all the responsibilities we have. So how do we do this? How do we learn this? How do we manage to navigate through this maze of change and this maze of what I'm now calling new language? Well, there's nothing better than to get Milani Kutsia to help us with that. Now, Milani is a specialist compliance attorney. She assists the banks, the long-term insurance industry, the investment industry, real estate, the legal industry, with FICA compliance and the training surrounding that. Her specialty is the drafting of the useful and practical policy documents that we all need and helping businesses implement these policy rules. So Milani drew her experience from having practiced conveyancing for a long time, 20 years plus, and is established herself as a well-known industry trainer and practitioner. So it really is a privilege for me and to introduce you to my colleague Milani. But before we do that, just a little bit of admin. At the bottom of your screen, you'll see there is a Q&A. That is the important one that you need to use for any questions that you might have during the presentation. So please feel free to ask your questions there. I will attempt to answer them on the fly. At the end of the presentation or the day after, we will collate all of those and distribute them to all of you together with the presentation. It was asked earlier on whether we will share this information. Yes, we will share the presentation with you as well as the Q&A, which we will collate so everyone gets the info afterwards. The chat, which we used earlier, where everyone said hello and where they're from and good morning, that was just what it was for. That's just the chat. The serious stuff is in the Q&A. So if you have questions, please focus on the Q&A. You will also see at the end of the presentation, we will pop up a poll. So that's just a little list of questions which we ask that you kindly complete for us. So that's me finished for now. I'm going to hand over to Milani. Milani, we've got a lot to get through. I'm holding on to the edge of my seat and I'm going to hand over to you. Thank you very much.
Thank you, George. As always, your introduction is so kind. Yeah, and thank you to LexisNexis, as always, allowing this opportunity for more webinars and more information sharing. The fact that we have reached the number of participants, for me personally, is indicative of the need for training that exists. And I wish I could clone myself, but unfortunately, we try and get to you with this information as regularly as we can. As George said during the introduction, this is the second of 6 webinars, which we put together not only just for general information and for educational purposes, but also because we have this deadline in the industry. A few of the industries are affected with the end of May deadline. And today I'll be dealing, amongst other topics of information, I'll also be dealing with one of the compliance requirements that need to be addressed before the end of May. And I don't know whether all of you feel the same as I do, but I feel that time just does not stand still. I mean, the last time we saw each other at the first webinar was a couple of weeks ago. And before we know it, it will be the end of May. So I think all of you can well imagine, with me focusing only on FICA compliance with these deadlines looming at the moment, how much I see. I see everything. I work with many law firms. I work with many accountancy businesses. As George said, I work with the long-term insurance and investment industries. I'm helping a few banks. I'm even working with FIC directly at the moment. There is so much going on. Every time we meet, there's a lot going on, but there is so much going on at the moment because of the fact that South Africa was grey listed, as we all know, on the 24th of February. And these deadlines, which are very serious deadlines for us in the industries. The deadline of 31 May has created a platform for the Financial Intelligence Centre to jump feet first right into the fines. So whereas before now, FIC has allowed opportunities for businesses after inspections where the businesses were found to be non-compliant with these requirements and most of the requirements, opportunities were allowed for these businesses to remediate the non-compliances, whereas FIC has run out of time in terms of the FATF Financial Action Task Force scrutiny, and is doing these umbrella audits or inspections. Now, I'll be talking about the directives 6, 7, and 8, and in particular Directive 8 throughout the course of the presentation, and I will be reminding all of you again on what the requirements are for your businesses to be compliant by the 31st of May. My intention with these webinars is to educate, but education takes a long period of time. We can't expect to know everything in one session, but also to try and avoid businesses from being fined. A fine, which would be an administrative sanction issued by your regulatory authority, is an unnecessary business risk. It's like buying a house and not insuring the house, taking your chances and hoping for the best. And we just can't operate that way. We've got to make sure that we are prepared for the moment or the time that FIC selects our firm or our business for an inspection. Inspections are very detailed again. These general inspections, that was sort of a sweeping inspection, those have also now come to an end. I'm dealing with a number of law firms currently, today, this week, who are being inspected by FIC at the moment, and these inspections have gone back to the very detailed inspections, very technical inspections, where your RMCP policies are being ripped apart and where the actual files are being tested again. So I think FIC has realized that, you know, doing these sweeping inspections and these, you know, sort of lightweight inspections that were at the order of the day for the last 6 months is not going to fly at the Financial Action Task Force when the opportunity arises again for our country's assessment. So it's got to be detailed, and it is. Even I, who's so experienced and have so much exposure, even I feel a bit shocked seeing the lengths of these inspections. When I read through the inspection reports, I often my mouth, you know, my mouth falls to the ground. These auditors are being upskilled. They know what they're talking about. They know all the regulations, and one can't expect to pass these inspections or audits just by sort of winging it. You've got to really look at all the source material and ensure that the processes in your offices reflect the legislative policies. So as per usual, I'll be putting my video off so that we can all focus on the PowerPoint presentation. A lot of care goes into the preparation of these PowerPoint presentations. It's necessary for us to visualize these quite esoteric concepts. I mean, for us to visualize client due diligence in our experience as business people is often different to what the legislature envisaged when putting the laws together, of these concepts. So it's quite important that we try and start visualizing these concepts for real in practical, useful terms. How do we ensure that we comply with the client due diligence requirements? There are a myriad of client due diligence requirements set in the FICA Act, the FICA Amendment Act from 2017, all the regulations since 2019 when the FICA Act amendment was promulgated. George mentioned the General Laws Amendment Act. There's been directives, there's been public compliance committee, and there's just a lot of source material. And often that is what overwhelms us. So today we'll be covering the 4 client due diligence processes that you have to record in practical terms within your FICA policy, and your FICA policy and your client due diligence processes which you've recorded must be reflected and evidenced in your files. So you can't just put these rules in your policy and think that is enough. What is in your policy in terms of client due diligence, the requirements, your obligations, the rules which you've created in your written policy must be reflected in your files. So that is quite important. And then we'll run through the requirement for some of the industries and where a proficiency test must be done by the 31st of May, and some of the other industries, that same proficiency test, which you've got to go and create yourself in terms of Directive 8, and in line with the Public Compliance Communication 55, you've got to go and create this proficiency test. And for some of the other industries, as I said, that proficiency test must be written by all employees by the end of July. So let's run through all these client due diligence requirements. During the course of the presentation, as with the first session, I referred to some of the concepts by shortened reference. So there's always a few complaints or a few people who give feedback on these shortened references. And so it's quite important for us to understand these references, because these references must not only appear in your policies, but this is the language, as George said in the introduction, that we need to start using. So throughout the presentation, we will be referring to money laundering and terrorist financing, which for short is MLTF. In addition to your MLTF risk criteria and due diligence requirements, you also have to create your proliferation financing risk triggers in your policy and in all your working forms. So when I draft policy or RMCP policy, FICA policies for businesses now, I do not only refer to the MLTF risks that you try and mitigate by putting together the policy and the forms. I refer to it as money laundering, terrorist financing, or MLTF, and PF, proliferation financing risks. So those go together. And in your policies, you've got to refer to proliferation financing in the same breath. Dual use goods, that reference comes up a lot because you have to create methods or a methodology in order to determine whether any of your clients trades in dual use goods. It's a requirement. not only in the FICA legislation in South Africa, but remember the FICA legislation in South Africa is based on the international regulations published at the FATF. Now, I want you to understand what dual-use goods means. It really means products and technologies normally used for civilian purposes, but which may also have military applications. So in your assessment processes during your transaction in your office, you have got to somehow establish, and it is the somehow that we've got to create in a policy, you've got to establish whether your clients in the transactions trades in dual-use goods. In politics, diplomacy, and export control, dual use refers to technology, AI, etc., that can be used for both peaceful and military aims. Examples of these types of goods, or controlled goods as it's often referred to, include sat-nav, so satellites, missiles, nuclear technology, chemical, biological tools, night vision technology, which is often bought in South Africa for gaming purposes, for instance. Maybe your clients are involved in the manufacturing of parts for any of these types of items. Thermal imaging, models of drones, as you saw recently with the Russian and Ukrainian situation, becomes a very big issue. Things like aluminium pipes with precise specifications, etc. So these types of goods are known as dual-use goods or controlled goods, because if you want to manufacture any of these types of items and export them from South Africa abroad, you need special permissions and licenses to do so. So you will see in the policies that I create and in the client questionnaires, there are specific questions which raise this as a question for the clients to complete and confirm. Clients who deal in dual-use goods or controlled goods will know the meaning of these questions. And of course, clients who don't will just say not applicable or no. So you can't ignore dual-use goods questions or controlled goods, manufacturing, transportation, or exportation. That goes hand in hand with your proliferation financing. So it's important you understand the meaning of these terms. Throughout the presentation, I'll be referring to CDD, short for client due diligence, a variety of client due diligence processes. And throughout, please don't get confused. Whenever I say CDD, it means client due diligence. Often I'll refer to PCC. It's just easier than saying public compliance communication every time. So there are a variety of PCCs that FIC has issued over the last, I would say, 6 to 12 months, which clarify certain of the policy requirements. And we've got to take cognizance of these PCCs. There are many of them. And I feel quite blessed to have started reading the PCCs years ago, even before the Amendment Act became effective in 2019. So I've kept up to date with all the public compliance communications, which for short throughout the presentation I'll refer to as PCC. And then a lot of you still get confused with the reference to RMCP. RMCP stands for Risk Management and Compliance Program. Generally, I think both FIC and us, ourselves, refer to the RMCP as the actual policy. So it's the Risk Management and Compliance Program policy that we have to put together and that your client due diligence processes must form part of. Now, starting off in this discussion with the overriding snapshot as a whole of what FIC requires and where the client due diligence processes fit is on your screen at the moment. FIC and its regulatory framework, in other words, the law, requires all accountable institutions, and everyone in attendance here today, I think, are accountable institutions, a lot of law firms, some other businesses. You must comply with these 7 regulatory framework obligations. Now, we know what Risk Management and Compliance Program means. That's number 4 on your screen. That's the policy, because FIC can't figure out what your program is, who does what, who asks which questions, what you do next, etc., unless you've written it into your own policy. As part of that policy, You have to define for your own business what type of customer due diligence you will do. So if your business is a law firm and you only do road accident fund claims, of course, your customer due diligence will look different to the next firm down the road that does conveyancing. And that firm's policy and customer due diligence will look different to the firm down the road who only does litigation or commercial work. That's why templates are very dangerous, because each business's own customer due diligence processes will be unique to that business. Enforcing those customer due diligence processes within the firm is done by the compliance officer. Of course, ultimately, having a policy in place, following the customer due diligence processes in the office that get checked by the compliance officer will lead you to reporting more of your transactions and clients and monies that you facilitate to FIC. And all your employees, agents, if you're an estate agency, must be trained. We do a lot of formal training. It's important to have evidence of the training. So ultimately, the practicality of your FICA policy lies within your internal customer due diligence processes that you have created for your own business. Because if you haven't got proper customer due diligence processes, who does what, when it's done, what form is used, then who assesses the risk, how is it assessed, all those, you will not ever get to a point of being able to confidently identify something in your transactions, anything suspicious, to FIC. You won't know. And up until now, if you and I are honest with each other, that has been the challenge. We have an idea, because we listen to a lot of Mel's webinars, and we've read up and we know, we see through the bank, SARS changed all its rules last year with repatriation of money from South Africa. We know that money paid into our transactions from abroad take a few days longer. We know that all these things are going on. We've saw in the news the grey listing. You know, we've got an idea, but we don't really know how to create these customer due diligence tools in order for us to be able to report suspicious transactions and monies and clients to FIC. But you have to create these customer due diligence tools. You can't avoid it, because you'll fail an inspection if you don't. And we know that our starting point for any business, whether you've previously done your RMCP or haven't done your RMCP, whether you've done nothing or done a lot, you always have to go back to your policy, because everything that you do in your files must reflect in your written policy. So that is our starting point. When we start looking at bumping up or expanding on our client or customer due diligence processes, we need to go back to our policy, and we need to ensure that the updated customer or client due diligence processes reflect in our policy. The main source from which to go and gather guidance directly from FIC is contained in FIC's Guidance Note 7. It's a lengthy document that pretty much gives you all the answers that you're looking for. In other words, how do we start with a company if a company is a client? What do we need to do when we're dealing with a trust? What are we allowed to accept in terms of identification, etc.? So if you haven't downloaded FIC's Guidance Note 7, you have to do so as soon as possible. Often I have to refer to Guidance Note 7 when clients start struggling, start haggling, start becoming defensive. So if I've dealt with your law firm might have a difficult client. It's maybe a big transaction. You don't want to upset that client, so you're not sure what to answer when they say, why do you want the share certificates? Why are you asking for the proof of payment? Why are you asking for a salary slip or bank details? You can go and find the answers and some guidance for yourself and your clients from FIC's Guidance Note 7. It's an important document. It's a long document, so it's not that easy to read, but if you read through it slowly and you refer to the specific sections, you should get the answers. But Because Guidance Note 7 isn't as clear as it should be. I mean, wouldn't it be amazing if you just opened Guidance Note 7 and it said, if you're a law firm, this is what you do. If you're an accountancy, this is what you do. And because there's been such negative feedback given to FIC over the last year and a half, FIC thinks it's very clear, but it isn't. There is a lot of other source material which is continuously issued, which you have to take note of too. So you can't just use Guidance Note 7. You have to look at some other source material as well. We often think that we are able to identify the MLTF and PF risks, but are we actually following the risk triggers regulated by FIC? So as a law firm, you sit there and go, well, obviously the small transactions, the risk is little. It's like an assumption under which we operate. I get this all day long, every day from clients whom I am assisting. That always say to me, no, it's fine. We've been doing this for a long time. And then if you start looking into the actual client due diligence processes, you realize that the actual FIC guidance is not followed. So we've got to actually go and find our primary guidance from FIC directly. Now look, I've just taken a few of the PCC numbers and put them on the screen. There are so many public compliance communications issued, and then there's some that get withdrawn, and then there's new ones issued. These are a few of the prevalent ones. This is where your source material will come from in creating your client due diligence processes. Obviously, you always have to look at your act. Then you have to read your act together with the Amendment Act from 2017. Then the FIC's Guidance Note 7 is one of the most important source documents. There's a Guidance Note 7A, which deals with more detail. There's a PCC 5C. How do you register? When trustees must register. Lots of issues with trusts and whether only professional trustees must register with FIC, or if individuals must also register. What must appear in your RMCP, PCC 53? It's more detail. So it has enhanced Guidance Note 7. PCC 52, how to put together a risk criteria. PCC 51, very important document. Political influential clients and politically exposed clients. There's a difference now. The definition has changed. Screening of employees, and that ties in, PCC 116, ties in with the Directive 8, where you have to do a proficiency test. PCC 54 deals with proliferation financing, very important PCC these days. There's your reference to PAPIA versus FICA. There's always questions regarding the data privacy rules or the entitlement. Clients raise their data privacy entitlement or their rights when we ask them FICA questions. PCC 14, if a client deals on someone else's behalf, in other words, if it's a company and there's a representative. PCC 12A, what to know about FICA outsourcing. A lot of firms outsource their drafting functioning to someone like me. Are you allowed to outsource the actual risk and compliance functioning? Can you outsource like you have been doing, and we say you must do it because FIC says you must do it in these PCCs? Your screening functionality, when you screen your clients, must you do it yourself or can you outsource it to LexisNexis KYC? There is so much source material, and you've got to make sure that you keep abreast of the source material. In Chapter 2 of FIC's Guidance Note 7, for your benefit attending today, it defines what a business relationship is. So it's important that you look at that. Defines the basic client due diligence process, the enhanced additional client due diligence processes. What happens if you're unable to conduct client due diligence? When you must do ongoing client due diligence? And in the Guidance Note 7 that was published a while ago, it still speaks about foreign prominent political persons and domestic prominent influential persons. And those two references have now been updated in the General Laws Amendment Act. Surprise, surprise. This was in the anticipation of South Africa's grey listing. This piece of legislation tried to amend the FIC Act sufficiently for the FATF not to grey list us. But unfortunately, it didn't work. But be that as it may, the actual written changes to the FIC Act, which is contained in the General Laws Amendment Act 22 of 2022, are very important when you put together your client due diligence processes now. The definition of beneficial ownership has changed. So when you read Guidance Note 7, it says beneficial ownership is one thing. In the General Laws Amendment Act, it says beneficial ownership is something else. So you've got to use the most updated definition of beneficial ownership. The General Laws Amendment Act also deals very specifically with targeted financial sanctions and proliferation financing activities. So we know people like me who specifically specialize in FICA compliance, I see the focus changing from your basic identification of your clients and the money. The focus has now moved a lot towards the proliferation financing activities and targeted financial sanctions, because it's something that businesses have not focused on over the last 2 to 3 years. The definition of foreign politically exposed persons, domestic politically exposed persons, have changed. And now a new definition has been inserted in December for politically influential persons. So you see how it goes. George alluded to it earlier. The laws change quite quickly, and you've got to keep abreast. Because in your policy, you're going to say, okay, our business will look out for this type of political exposure. And then you've got to define what you will be looking out for, what you will be investigating. And this is where I'm seeing a lot of tripping up with FIC inspections. FIC actually points out in the inspection reports that the RMCPs are from 2022 and haven't been updated in terms of these amendments. And in terms of the Guidance Note 7, FIC says that customer due diligence refers to your knowledge about your clients and your business's understanding of the type of relationship that you have with your clients and what type of business your clients are in. So that really in a nutshell is what customer due diligence means. It's a lot wider than KYC. KYC was at the order of the day before the Amendment Act in 2019, where the KYC obliged us to identify our clients with the ID and their residential address. And then we had that regulated FIC affidavit that we used to use. All of that's fallen away now. And KYC is insufficient, general KYC. You have to apply quite a wide methodology, all sorts of questions you've got to pose your clients in order to ensure that you fully understand the type of business that your clients are conducting and that you have enough knowledge about your clients. Your CDD measures, if you properly implement them, will enable your business to better manage your relationships with your clients and to better identify possible attempts by your clients to exploit your business for illicit purposes. There's no point in assumption. We can't assume all our clients are lekker and cool. We've got to actually employ a methodology. We've got to have a client questionnaire that we get all our clients to complete, for instance. So it's a key component for FIC inspecting your business. That's one of the primary things that they inspect, is what your customer due diligence or client due diligence processes are. And they start by looking at your policy, and then they test your files. And for your own business to be able to mitigate the risk, because you wouldn't, unless you applied a proper methodology, client due diligence methodology, you wouldn't be able to identify crooked money or suspicious behavior or activity of clients. So having a proper client due diligence defined and recorded in your policy means that you are properly able to risk assess your transactions in which your clients are involved. So you can't avoid defining those proper client due diligence processes. So let's go through the variety of client due diligence processes. The first type of client due diligence process is, of course, always the basic CDD process. This basic CDD process consists of certain steps which your business will need to take in transactions in order to firstly identify the clients, which we've always done, by the way. And that is where you establish the client's identity and where you are obliged to obtain a range of information about the clients, because the ID copy that we have traditionally always collected, it doesn't tell you much about the client. Hey, it just says this is the client's name and surname and ID number. This is the client's date of birth if they're a foreigner. And you are now expected to collect a lot more information to give you a basic and a wider idea of the client and what the client does for a living and how they live their lives and the type of money that they save. In most cases, this information is provided directly by your clients in response to questions that you ask the client whilst you're busy onboarding the client. So at the beginning of your interaction, you have got to ask the client certain questions. So I'm saying to all of you this morning, to determine what type of questions to ask will depend on the type of business that you run. But now I've given you a bit of background. You've got to check what type of trade your client is involved in, what type of occupation your client does, what type of business he runs, what type of savings he's got. All those questions must appear in the questionnaires at the onboarding stage. Your business must choose the type of information by means of which they will be able to establish the client's identity and also the means of verification. You know, it's not enough just to ask the questions and for the clients to answer the questions anymore. It's also important that as far as you are able to, that you verify the information. So it's the two-pronged step now. Firstly, the identification of all the information, the guy's name, surname, ID number, marital status, home address, business address, telephone numbers, but then source of funds, source of occupation, source of savings, bank account details, whether they're associated politically, etc. And then once you've obtained that information and you've looked at the copies of the identification documents like the ID and the utility bill, then you've got to verify that information. I want you to refer you to Section 21 of the FIC Act. Often Section 21 and non-compliance with Section 21 of the FIC Act is the reason why a firm or a business fails a FIC inspection. Because there's no problem with natural clients or individuals, but we've got big problems dealing with companies and trusts, small companies, I think, just from my 20 years experience. It's easy enough for us to identify and verify individuals' details, maybe not so much a source of funds, etc., other than asking the client, but it's very difficult for us to verify or even identify those different corporate layers. And Section 21B is often the reason a business fails the entire FIC inspection, because they haven't actually specified in their policies how best and what they need to identify and then verify in terms of corporate vehicles being used by clients. So companies, trusts, partnerships, etc. A lot of time has to be spent by you in creating your client due diligence, your basic client due diligence requirements. That's your business's standard in compliance with the Guidance Note 7 and Section 21B. Because for not only individuals, but for corporate clients, you have to establish the nature of the client's business, the ownership and control structure of the client, and the beneficial ownership of your clients if it's a multi-layered corporate vehicle. And then you must take reasonable steps to verify the identity of the beneficial owners. Now, looking at this, being the basic CDD, there's quite a lot. There's quite a lot of requirements here. And we need to go and specify in our policies exactly what we do once we've asked the company representative to complete the company questionnaire and the individual representation questionnaire or representatives questionnaire in compliance with Section 21B. We must then go and create rules in our policy of what we do with companies and trusts who do not cooperate in supplying information for us to identify and verify the beneficial ownership of that company or that trust. So you've got to create the rules. And you've got to understand, if you're not able to verify the client's information that they've supplied with the client's cooperation, so if the client refuses to cooperate and you can't gather any share certificates for a company or, you know, any type of proof directly from the client, then you need to go and create rules in terms of which you have to rely on other tools as a backup, like a LexisNexis KYC, or a SIPC search. And if you're unable to verify shareholding or beneficial shareholding or ultimate controlling shareholding from LexisNexis KYC, so in both your client interaction and your digital third-party database, in your backups, you're not able to verify, that needs to then lead you to reporting that transaction to FIC. So the very start of your transaction must entail full identification with both your client's cooperation and relying on third-party databases through LexisNexis KYC, for instance. And secondly, verifying the information. And if you're not able to do all of that at the beginning of your transaction or your interaction with your client, you will probably then have to report the transaction to FIC. But you need to put in your policy, my basic client due diligence for companies entails this. If I'm not able to get all this information either directly from the client or from LexisNexis KYC or other third-party databases, then the next step is that we report the transaction. That is what basic CDD means. What the rule is, how you're going to fulfill the rule, and ultimately what you do if you cannot fulfill that rule. So verification of clients' IDs and information for that matter entails that you as the business, you must corroborate the identification information by comparing all the information. You must take the questionnaire, compare it with the copy of the ID the client sent with the questionnaire, and then corroborate or verify it on LexisNexis KYC. But you need to create how you will be doing it. You need to create the rules in the policy. So you can't just say in your policy, yes, we're aware we must identify and verify. No. Under basic client due diligence, which is a clause in your policy, you must say, for identification purposes with individuals, this is what we will do. For identification purposes with companies, this is what we will do. And then you refer it to your client questionnaires. Then next up, you'll say, as part of the basic client due diligence process, this will be written into your policy, we have to verify the information collected from the client. And we verify it against the copies client supplied and against third-party databases. These are the third-party databases that we will verify against. Then the third thing is you must say in your policy, this is our rule for identification, this is our rule for verification. But unfortunately, if we can't verify the information from all those sources that we have mentioned in clauses 1 and 2, then we will be obliged to report the transaction to FIC. That is what FIC wants to see. The methodology, the tools, what you will do step by step. Not only do you need to verify the identity, and for companies, the identity of the shareholding and the controlling shareholding, but you must also identify and as far as possible verify the business in which that client operates. That's why you've got to ask those questions. It's not just the bank that asks, what do you do for a living? Us, as accountable institutions, whether you're a law firm or whether you're an arts dealer, you have to ask what type of business the client is in. And again, to find out what you need to ask in your questionnaires, you must refer to FIC's Guidance Note 7, plus some of those other public compliance communications, PCCs. You must establish the type of business and trade that your client operates in. You must gather all the information needed for you to conduct a proper risk rating. So let's call it the fact-finding part of basic client due diligence. These beginning processes as you onboarding your client. So first you must ask questions in a questionnaire because you must identify the client, the status, and whether the client is who he says. With companies, the shareholding. Trusts, the ultimate beneficial owner in the trust. Then you must verify that information. You must create your rules for verification. Then thirdly, you must look at what you've now gathered during steps 1 and 2. Because the next step, And the next thing that you will need to do in the basic client due diligence process is risk rate your transaction. So now you've gathered information from the clients, about the clients. Now, next up after this is where you actually risk rate your entire transaction, part of which involves your clients. So you have to sort of follow a sequence, guys. You have to create that sequence. In the policies which I create, I have a 9-step basic client due diligence process. Came to me one night whilst I was sleeping. And I just realized there's no point in like putting this in policies, just saying you've got to do this, but people don't know how to do it or when to do it. Creating practical, useful steps for your secretaries to follow, so that when a secretary gets a new instruction, she knows exactly what form to use, what to do when the form comes back, and then ultimately when the risk rating of the transaction must take place. Because in your questionnaires, you ask for identity, then you must verify the identity, you must ask for occupation, then you must verify the occupation, you ask questions about political exposure and influence, which the definitions have changed now recently. And then ultimately, when you have now overviewed all the information that you collected, that you verified, now you can do your risk rating. So ultimately, as a reminder, step 1 in the basic client due diligence process must always involve a proper client questionnaire. Not a flimsy client questionnaire where you ask for personal particulars, but you need to bump up that client questionnaire that you've always used by asking questions on the ID, the marital status, the telephone number, the employment, the trades, political exposure, political influence, source of funds, bank account details, source of wealth, and then your extra layering for your entities involves not only the basic company information in the basic company questionnaire, but the representative of the company, and the representative trustee of the trust. So you've got to spend a lot of time refining your questionnaires. My questionnaires started, the first drafts I did was 3.5 years ago. They were just 1-page or 2-page long. Now my questionnaires are long, very long, 2, 3, 4 pages. But I add questions as I see the requirements change. You must develop proper client questionnaires. It's always step 1 of your basic client due diligence process, because you've got to collect information directly from the client. It's the only way to do it. You must ask questions about occupation and trade. Get the client questionnaires completed. Request copies of required verification documents that you want from your client. And then once you've got that, then you've got to do your own identification. Check, check, check. Corroborate, screen the client's information on third-party databases, compare the screening reports with the copies supplied by the clients with the information that the client has given you. That is a process. So that's it. So identification, verification, then you do a risk rating. During the course of your transaction, and in accordance with Fixed Guidance Note 7, that expects you to apply additional client due diligence at some points during the course of your transaction. And you need to establish when. Read the Guidance Note 7 and read your PCCs. Because it's a very difficult thing just to figure out what additional CDD is. And when your firm or business is inspected, FIC likes to hammer their harp on additional CDD and enhanced CDD, because they realize the basic CDD, everyone sort of got that under control. So additional CDD consists of processes which you need to take in your transactions to further identify and verify information. So your basic CDD will be a basic identification and verification. Your additional CDD is where you do further identification and verification, and this is what you need to define in your policy. You can't just expect secretaries or your employees to know when they are supposed to be asking for another copy of a passport to corroborate the ID if the information needs to be further corroborated. You must create these rules in your policy. FIC wants to see that you have additional CDD rules written in your policy. When are we supposed to be asking for more copies? More proof of the source of funds, newer copies, original documents for copies that were supplied before. When you do further third-party verification, where you specifically yourself go and Google the client again. And you will have to create these rules because there will be a lot of instances whilst you have now basically identified and verified the client's information where you need, for your own benefit, where you need to clarify vague information, especially when you try to verify shareholding in companies, controlling shareholding, and beneficial controlling companies or trusts. It's difficult if your client does not cooperate to further verify information surrounding shareholding. Now you need to create the rules in your office that says, we get the questionnaire to the company. Then we look at the questions and the answers. Then we check that we've got share certificates. If we do not get the share certificates from the company representative client, then we do the following. Create those rules. Then say, we'll ask the client a first time. Then we'll ask the client a second time, again. And after a third time of asking the client, we stop asking the client. Then we will utilize our backup tools. We will ask LexisNexis KYC to do a specific verification of shareholding and see what they come up with. Then we'll do a specific Google search. But you can't just fall in from step one, right at the beginning, by doing all of those things at once. That's why people don't do it. It's too overwhelming to think about it. You need to go and create the rules. You try your basic CDD. Hopefully the client cooperates. If they don't cooperate, then you've got to apply additional CDD. And you've got to write your rules for your business into your policy. What is additional CDD for you? How will your secretaries deal with difficult clients? Or with clients like companies where the shareholder certificates are not provided. You have to revisit the client. I can't tell you must do that. Obviously, that's the first point. When you look at everything, you see, oh gosh, I still don't have the shares or the shareholders verified. Now it's a month into your transaction. Don't need to panic. But you will panic and your secretaries will panic. And then we make mistakes and tell clients, oh, we're going to report you to FIC if you don't give us the share certificates, which you're not allowed to do. That needs to appear in your policy. When you say in your policy, if the basic CDD steps do not yield clarity on the shareholding, then we will apply additional CDD, which involves A, B, C, and D. And A being we will revisit the client 3 times within the first month after that. And if the client doesn't cooperate, then we will do this, then we will do that, then we will report. That's the point. Of course, additional CDD is often required when you need to further investigate the source of the funds in the transaction, because ultimately in your basic CDD questionnaire, your client questionnaire, which is step 1 of your basic CDD, you have the question, please confirm the source of funds you used to buy this property. Yes, that's the question you've got to ask your sellers. Because often we just ignore sellers in our property transactions, for instance, and we just focus on the buyers. But that's not how it should be, because you are obliged to ask the sellers of your properties where the funds came from or emanated from to buy the asset that you are professionally transferring for them. And they often like to give vague answers because sellers and buyers and clients of ours, all our businesses, they're not used to being asked these intimate questions by attorneys. And that's why attorneys have been targets for crooks. They put 10 million through a transaction because they know we're just going to ask for a copy of the ID and the utility bill. But now your questionnaires have to include questions surrounding the source of funds. Source of funds for the transaction. Source of funds generally. Source of wealth generally. How they generally make their money. And where they give vague answers like savings, that gives rise to the need to apply additional CDD. Because if it's R1 million involved and they say savings, very few people can just save R1 million. So that doesn't make sense to me, and I don't accept that as an answer. If a client chooses to be lazy and give me the answer for savings as the answer for source of funds, then I will jump into my additional CDD rules in my policy, which says, if a client gives me a vague answer to source of funds during the basic CDD process, then I will have no choice but to ask him to prove those savings. So I don't have to ask him for proof of source of funds in the beginning. I only ask him for proof of source of funds as additional CDD step when I can tell he's trying to be vague or where the information doesn't make sense. When he says he's a policeman or he's retired, but he says he's saved R1 million. To me, that doesn't make sense. So that's when you apply additional CDD steps that you've got to create in your policy, because you have to further investigate source of funds, not in every transaction. Most of your low-risk transactions you won't have to, because the clients will just tell you where the money's from. They'll tell you they've sold a boat, or they've sold a car, or they inherited money, or they sold another property. That's fine. For that, you don't need proof. But when they start using the word savings, and it's R1 million involved, no. To me, that doesn't make sense. And what I'm saying to you this morning is that I can tell you this. That's why you're all still in attendance and you'll keep attending these webinars. But until you actually sit down and create your own rules, according to the Guidance Note 7 in your own policy, there will always be stress and anxiety at your secretary's desks, because your secretaries don't know what to do when a client refuses to cooperate. And you've got to create the answers, the solutions for your secretaries in your policy. So your additional CDD processes, which you have to define in your own policy, very useful with useful terms. You have to apply where information is overviewed. So when you look at everything, so you've got to create the time period when the requirement is to be fulfilled. When are you going to look whether you need to apply additional CDD? In your policy, I need to be able to see the answer. Within a month after I've opened my file, I will do an overview of all the information that we collected during basic CDD. And in the following instances, more information will be gathered. So that's when you define your own additional CDD process. So that's when you engage with clients again or use other tools available to your business. Additional CDD can be conducted at any time during the transaction, but in particular, once you've risk rated your transaction. Because in the policies I draft, FIC always says, well done. If you have risk rated your transaction and it's medium or high MLTF and PF risk, when it's medium risk, you have to apply a certain set of additional CDD rules. When it's high risk, there's a certain set of additional rules. So you've got to go and create these things. When it comes to enhanced CDD, you would think additional CDD and enhanced CDD is very similar to each other. Guidance Note 7 sets out when and how you've got to apply your enhanced client due diligence steps. Enhanced client due diligence consists of processes which you need to take in your transactions to finally scrutinize the source of funds versus occupation versus industries of trade. So this is where it's serious. I would say additional CDD is the attempt to get more info, so that you don't have to report the matter. Enhanced CDD is where it's serious, where you've picked something up in your transaction, like Chinese funds or Russian funds or any other trigger. It's a big deal. It's a lot of cash. The guy's occupation doesn't line up. You got all that information through additional CDD. Now, especially when you deal with entities, and enhanced CDD particularly applies to companies and trusts, is where that extra layering you've got to investigate. So I define enhanced CDD as opposed to additional CDD to apply specifically to companies, trusts, partnerships, etc., the rest of the entity varieties. The actual source of the funds, I must investigate that when I'm dealing with a company. Always remember, the Guptas took advantage of our inability. Maybe we were unaware that we had to, and still have to, investigate the beneficial ownership and corroborate the beneficial ownership versus the source of the funds when we're dealing with companies. The Guptas had companies that bought and sold a lot of properties to the worth of about, or value of about 500 million. Attorneys were involved. Maybe your firm was involved. Maybe your business was involved. You wouldn't know now. and they exploited our lack of confidence in investigating the actual source of funds. So in your policy, you've got to read through Guidance Note 7, and then you have got to go and create rules to say, enhanced client due diligence will apply when, then you say company, partnership, when things aren't clear, information's vague, where I want to investigate the actual shareholding, who the controlling shareholder is, where clients supply all information honestly. Of course, that reduces your risks. And then it's not necessary for us to ask the company to actually give us proof of the source of the funds. So finally scrutinizing the source of funds versus occupation versus industries of trade as part of your enhanced CDD processes. To define that and record that in your policy requires a more in-depth look by you at Guidance Note 7, setting out the rules for your secretaries to follow. So if it's a company, this is what you need in your file. If you don't have this in your file, it's a high risk. If it's high risk, then this is what you do. Try KYC. If KYC doesn't give yield any information, you go back to the client. How many times must you go back to the company representative? At this stage, you might now want to get a questionnaire completed as enhanced CDD by all the shareholders. Maybe the representative of the company that you dealt with up until now has been vague in his or her information. So it's not necessary when you deal with companies from the onset to get all directors and all shareholders to complete the questionnaire. Now, you get the company questionnaire completed with all these relevant questions and the company representative. That's it. That's your basic CDD for companies. Enhanced CDD, when it comes to companies, require you to get all the directors to complete the questionnaire and all the shareholders to complete the questionnaire. That's where you do further investigation, who these directors are, who the shareholders are, where the money's from. Of course, you have to, because the law says you must take enhanced CDD steps when your client has indicated that they operate in the dual-use goods or controlled goods trades, or where they may be associated with proliferation financing. It's a big issue across the world at the moment. The transportation of weapons of mass destruction or just weapons which enable war activities. South Africa is a big target for proliferation financing activities because of where we're situated. So when you are inspected by FIC, a lot of emphasis is placed on the questions that you have in your basic questionnaires as part of your basic CDD. A lot of emphasis is placed on what you do when you've been able to identify and verify that the client you are dealing with in your transaction is actually involved in one of these dual use or controlled goods trades, or may be associated with proliferation financing. It's not unheard of to pick this up, guys, but obviously you need good basic CDD questions in your questionnaires. Then you are obliged to take enhanced CDD steps, which you must create, again, investigating the actual source of funds. So it might emanate from a sale or a trade or an export to Russia. Now, I know you're all sitting there thinking, oh, yeah, these crooks are never going to tell you the truth. But you'll pick it up if you get a proper questionnaire in place. You'll pick up the attitude. You pick up the behavior. If people become defensive from the onset, there is a suspicion. Now, you need to put that in your policy so your secretaries know what to do. And you are obliged to create special enhanced CDD steps when you have been able to identify and verify clients who are politically exposed, politically influential. So that's when enhanced CDD applies. Enhanced CDD applies when you have multi-layering in companies. So the shareholding or the shareholder is a company that's also got shareholding, multi-layering, automatically high risk. And for that type of high risk transaction, you have to apply enhanced CDD. Now you need to create your enhanced CDD for multi-layered companies. The second type of client that you pick up in which you have to apply enhanced CDD is when you pick up that someone trades in dual use or controlled goods or may be associated with proliferation financing activities. And the third type of client is if you picked up and are verified that the client is politically exposed or politically influential. Again, for all three of those types of clients, your enhanced CDD consists pretty much of a full investigation, and your client must be approached with that investigation. So I call it an investigation, where we've got to say to the client, we've picked up that you're politically exposed. Now we need to verify the source of funds in this transaction. We see in the client questionnaire that you completed 2 months ago, you said savings. You have to supply the proof of those savings to us now. So you've got to go and create these rules surrounding certain types of clients that you're dealing with. And then you've got to take those certain types of clients right back to the basic CDD questions and your processes in the basic CDD. So you can't even get to enhanced CDD unless you have a proper basic CDD in place. So enhanced CDD processes will apply where your client or your transaction exhibits medium or high money laundering and terrorist financing and proliferation financing triggers. That's where you have politically exposed or influential clients, you're dealing with entities and you just can't get to the bottom of the shareholding, where the source of the money is dubious or suspicious or vague, and the geographical association of your client. If it's a Chinese or Russian or UAE, Dubai, all those grey listed countries. So can you see how different each of these processes are? You can't really even just throw them all in one pot, because that's where the confusion comes from. And then FIC is just going to fail you and you're going to pay a fine. You can apply enhanced CDD at any stage during the transaction, but especially when your transaction has been risk rated as medium or high money laundering, terrorist financing, and proliferation risk. So you've got to approach your policy as a storybook. Beginning of the story, how you do all these assessments, how you follow your CDD steps, when you do additional CDD, when you do enhanced CDD. And in between that, you've got to do your risk rating, because your risk rating triggers the need to do additional and enhanced CDD. Isn't that interesting? Now, I wanted to point out for all businesses in attendance today, there's a PCC that a lot of people don't know exists, or they know it exists, but they haven't really read through it. Please do. Public Communication, Compliance Communication 31A. It's a relatively new PCC, which restricts your business from receiving funds before doing certain of the CDD steps. I mean, law firms, there are a lot of law firms in attendance here today. Law firms always wonder if they're allowed to receive payments, even if it stays in your suspense account, before when? You've got to create your rule in your policy. You've got to say, before all these things have been done, we are not allowed to open a trust account. You've got to follow these PCCs, guys, otherwise you'll find your audit and your inspection. So read through the PCC, because it also refers to Section 21 and Guidance Note 7. It says here, you have to at least identify your client. And if there's an entity, you have to identify the beneficial owners with that client and verify that information before you may complete your transaction. So this means that your business, you may start the process related to the conclusion of the transaction, but you may not complete the transaction before the institution concludes all the verification and the enhanced and additional CDDs. So it's also important for you to build into your RMCPs the timing of your different steps, because we all know a transaction takes time. So what must you do at the beginning? Then you're allowed to open the trust account. Then after that, you do the following. Then you do the risk rating. When must the risk rating be done? When must the additional CDD be done? So FIC says you mustn't increase your own risk by receiving funds without even at least identifying the person. You must make sure that you at least identify. So now in your policy, according to PCC 31A, you can open a physical file, but you're not allowed to open a trust account until you've got the questionnaire back and the ID copy back. Then what do you do next? So the center's view, so FIC's view, is that only once a prospective client has been identified and verified and your business has taken a decision to accept that client, then you can accept funds. So for your firm or your business in attendance, you've got to put that in your policy, because FIC is going to look at that rule and then test your files. So there's no point in having an RMCP policy that says you're not allowed to open a trust account until you've got the ID and the questionnaire back. But in real life, your actual file, your secretaries are opening trust accounts left, right, and center because there's a disconnect between your secretaries applying the policy. That's also where firms and businesses trip up. FIC says your business shouldn't accept funds until at least your identification and verification CDD process has been completed. So this means you've got to do the beginning things, basic steps. And then at some point during the course, later on, you can do the risk rating. Timing and defining your timing requirements is incredibly important for the files to reflect the policy. In terms of ongoing CDD, and this is the last CDD process, FIC is not very clear on exactly when they expect us to redo our basic, additional, and enhanced CDD steps. We have to create our own requirements in our policy. So in my policies, for normal law firms, I require ongoing CDD or create the requirement to do repeat the steps every 12 months. But there are certain businesses where the steps might have to be repeated every 3 months. But you have got to create the rules surrounding ongoing CDD. So you can think for yourself the different type of transactions that you're handling. And then you've got to go and create those repeat steps. But you can't not have ongoing CDD forms and a management form that the attorney must sign or the manager must sign off. You've got to go and create what your rules are if your business relationship with the client is ongoing or long-term. Then you must go and create which steps must be completed when. So in my policies, I provide that the CDD steps must be repeated every 12 months. This means a new questionnaire must be completed, new verification copies, new screening reports, all those 9 steps must be followed again. Risk rating is done again. In your business, you might have to do it every 3 months. Some businesses have to do it very regularly, might have to do it every week. But I can't say what is right or wrong. I can tell you what the guideline says, and then you've got to create that in your own policy. So ongoing CDD is required and rules surrounding it, where your deal is long-term. It's a long-term transaction. We have a long-term relationship. Think of property developers. If you're an estate agent, think of an ongoing rental that's renewed every 12 months. Look, think of an estate that takes 12 months to wind up. So that in a nutshell is all the due diligence processes. So you can get guidance on what they are, who must do them, when they must be done. But ultimately, once you've decided that, then you must record it in your policy. You can't have nothing in your policy about enhanced CDD. FIC will fail you in the inspection because they expect you to recognize when you've got to do enhanced CDD and what is done. They look at your policy, then they test your files. Now, to move on to the need for all businesses, all accountable institutions, to have a proficiency test done by the employees. This requirement was created in Directive 8. It was published by FIC on the 31st of March. The deadline for this requirement hasn't been set, even though for some of the industries, the compliance deadline is end of May. So we know that FIC is going to check that you have done your proficiency testing with your employees also by the end of May. For other industries, it's the end of July. And again, for those industries, the proficiency testing will be checked as part of those industries and those businesses' compliance by the end of July. For the record, law firms, estate agencies, trust administrative companies, their due date is end of May. So for any attorneys in attendance, you have a few weeks to get all these things done. Now, the proficiency testing is interesting because it's never been a requirement. FIC is not interested in how you check whether your employees are proficient. But I think FIC has learned its lessons with these individual one-on-one inspections over the last year. They interview your secretaries, and they have found through the interviews that all the bravado put forth by the directors often is not reflected in what the secretaries say in the interviews. Secretaries often say, we don't know what we're doing, we're not getting proper guidance, the training is just too flimsy, we don't understand the forms. So it's for that reason that FIC has now implemented this compulsory proficiency test that you've got to put together. You've got to figure out yourself what you must put in the proficiency test. And you've also got to scrutinize and screen all your employees against the TFS list, the terrorist lists. There are two of them, TFS and the UN 1267 lists. So there's two things that you've got to do in order to comply with this directive. So Directive 8 calls for your business to screen prospective. So obviously we've got to implement some proficiency test for new employees that you're interviewing to appoint, and current employees to check that all your employees are competent and have integrity. And this screening or this proficiency testing must be done periodically. So this is the requirement in Directive 8. And secondly, all the businesses affected must screen all employees, and obviously when you interview new employees, before you appoint the new employees, against the targeted financial sanction lists, of which there are 2. And you've got to evidence this. So let's look at the first half, the competency test, or I call it the proficiency test. It would be nice if FIC had given us an example of this test. But what FIC says in the Directive 8 is that we must look at PCC 55, which I did for you. And it says, FIC views the screening for competency as determining whether your employee has the skills, the knowledge, and expertise to perform their functions effectively. Your business must have the flexibility to determine the manner in which the accountable institution or your business will screen for competency. So you've got to create your own proficiency test. So the proficiency test that I've put together, because we are allowed to put it together in any form or manner which we want, I've done a 50-question multiple choice. And it's conducted with a physical test that's emailed to the employees all in one go, 10 minutes before the test starts. So you let them know a week before that the test will be done Friday at 1 o'clock. 10 to 1, you email the test, and at 2 o'clock, they've got to hand the test in. They can complete it digitally or they can print it, and someone in the office has to mark the tests. And once you've marked the test, I've created a 90% pass rate. It's okay if we get there. We can deal with the mitigation of the remediation for employees who maybe haven't passed the test after the 31st of May. And you've got to exhibit your competency or your proficiency test. And then secondly, you must screen against the TFS lists all your employees in your business. And if you employ new people, you've got to do the proficiency test and the TFS screen. So if you are not with LexisNexis KYC, they make the TFS screening for your employees and your clients very easy. And we can assist you with the proficiency test if you need that. If you haven't yet put that together, it's not easy to put something like that together. In addition to all of that, Directive 8 also says the word periodically, according to FIC, means at least every year. So you and I are going to continue seeing each other for the next years to come, because they're going to check that you've done annual proficiency tests. You do not have to screen the employees on the TFS list annually. You just need to do the proficiency test annually at a minimum. So some firms do it more regularly, every 6 months. And in terms of the penalties, which are even more prevalent now, firms are being fined between 250 and 500,000 Rand. I've seen this firsthand. State agencies are being fined between 5 and 100,000 Rand, 5,000 and 100,000 Rand. So any way in which FIC feels that it is going to get quick compliance is by using the stick approach. Now, I don't think we'll ever see 10 million, 50 million Rand fines, but be that as it may, it could be for the bigger businesses, because if we take the banks who are now being audited for a 3rd time, all the banks get fined 25 to 50 million each and every time. Investec's been fined twice. I keep saying it, Nedbank's been fined twice. Nedbank's going through a 3rd audit. So for all the firms on Nedbank's bond and bond cancellation and other panels, please understand that Nedbank will be auditing your FICA compliance as well. So it's for many reasons you've got to get FICA compliant. It's to remain on the bank's panels, because the banks are going through hectic audits. So they've got to show that all their panel attorneys are compliant. And when FIC comes knocking directly on your door, and to make this deadline, which is literally around the corner. And that, ladies and gents, allows us a few minutes for questions and answers. I know it's very overwhelming. I know it's probably still very confusing, but I think just focus on separating these due diligence processes firstly. And then secondly, go and read Guidance Note 7 to see what you can pick up for yourself to put in your policy. And then thirdly, work out what you need in your forms that your clients complete and that your secretaries use. And if you just do that in the beginning, you know, as an initial step, then I think you'll get a lot further than what you might be up until this point. So George, I'm quite sure there must be 100 questions.
There were about 100, but I've answered a lot of them in the process. But like I said in the beginning, we will collate them and we will distribute them. But firstly, Lonnie, thanks so much. I mean, you have the ability to give an overwhelming amount of information or complexity in a very structured and simple way. And I really think it's delivered so well. So thank you so much for your time and effort in doing that. But we're not going to let you off the hook, Milani. There's some questions that I'm going to fire at you. So easy it ain't going to be. So one of the attendees asks, they've got more than 2,000 employees. Must they screen them all before May 2023?
If you're an accountable institution, depending on the industry that you're in, some industries' deadlines for screening is end of May and some end of July. So if you need a bit of advice on that, maybe after the webinar, we can assist to see what your industry, you know, what industry your business is in. And yes, unfortunately, it's selective. It's not a certain class of employee. It's all employees must be screened on the TFS list.
Okay, you've just answered that question for me. I was going to ask, irrespective of what the person does in your organization.
Yeah.
Okay. The retrospective working of these things, there are a number of questions that have come in saying, you know, what about all the customers I've already onboarded and already have in my books? Do you have some comments on that, Milani?
Yes, good question, and it comes up quite often. So you have to accept that you have followed old FICA rules up until the point when you implement your new rules. That is how life works. You have conducted many thousands, hundreds of thousands of transactions up until the point when your new rules kick in. Now, it's a process to get to that point where your new rules kick in. And therefore, my advice is, and FIC accepts, that we draw a line in the sand. We decide. Once we've got our new policy in place, we've done training to all the employees, we decide 10 May is the date for implementing the new rules. No old files. There's no retrospective application of the new rules. We've got to accept that the old files have been FICA'd on the old rules. And the new files, following the implementation of the new rules, which is obviously a management function that is done on resolution by the directors of your business, like all other policy implementation in the business, the day the directors sign the implementation resolution, every new file from that date forward must evidence the new rules. And so there is a period of transition that we are currently in. FIC accepts the fact that you haven't been complying with the rules. But if you've got a great policy in place and you can see the commitment, or FIC can see your commitment, FIC accepts your promise that going forward you will follow the new rules.
Thanks, Milani. So here's a question, and in the past we've had it before, it's almost that sort of chain of events about where the responsibility lies to do the inquiries. A landlord owns a business premises, which the landlord lets out to a tenant with the use of an agent. Who is responsible? Is it the agent or is it the landlord to do the
it's a professional
verification?
It's a professional verification. It's a professional requirement that attaches to your profession. So that's why it's accountable institutions, which are defined to be subject to the FIT laws. So if the landlord is renting his property incidentally, he's just a normal landlord, he's got a little flat, he appoints you as the agent. The agent is defined as accountable institution. So due to the professional services that the agent is rendering, the agent will have to conduct all these client due diligence steps.
And if both in theory are, so it's a commercial property landlord, so they're an accountable institution by virtue of the size of the transactions, but they also make use of an agent.
Then
Does
they
that
each have
change at all?
individual independent requirements. So the one can rely a little bit on the other one, but independently they will be inspected. So then they can't point fingers and say, oh, my agent should have done this, and the agent points at the developer. Both of them will be fine because you are individually responsible for your own requirements. That's why the policy is so important, because if you are working with other accountable institutions in your operations, you've got to create the rules in your policy, which allows you and your professional partners to rely on each other's documents and steps.
Yeah.
It's not an assumption. We can't assume it's like that, because then we're going to pay a fine. And then the developer or the owner of the commercial property is going to be pointing a finger, and the agent's going to be pointing a finger because they assumed that they were fine, but they never recorded it into their policy.
Okay. And Melanie, one of the questions that came up is, it was you sort of in passing mentioned, if the funds came from China or from Russia or from Iraq or so on. If you can just elaborate a little bit on those lists and
no, that's a separate presentation. The actual risk triggers. I think one of our next webinars in the series, I am going to deal specifically with the risk criteria that you've got to create in your risk rating form, and therefore the questions in your questionnaire, because they go together. So it's a whole presentation on their own. But obviously, in creating your risk criteria as a business here in South Africa, you've got to think, well, you take your lead from FIC, because they put the some of the risk criteria out for you in the legislation. You've got to look at geographical risk criteria. You've got to look at the internal, public sector, private. There's a lot of things that you've got to look at in South African businesses to create your own risk rating criteria against which you will risk rate your transactions. Also from industry to industry. I mean, I deal with, I keep using the art auction businesses. Their risk criteria will be very different to a law firm's risk criteria, because they generally only work with the owner of the art piece and then the buyer of the art piece. But in certain instances, they do have dealers as intermediaries. So we create their rules. Then in a law firm, you've got sellers and buyers of properties. Then you've got non-conveyancing transactions. Then you've got different layering. Then you work with a lot of foreigners because you're an attorney that's known in the foreign investment sphere. So there will be different risk criteria that you've got to look at. But certainly the logical risk criteria, the fact that we are situated on the African continent, that is a consideration, because we think we're so far away from all the trouble, but we're actually not. We're right in the middle of the trouble. In fact, we're right in the middle between the East and the West, and we're a maritime country. So there are a lot of ships that can pass. Think of all the human trafficking. Think of all the illicit pipeline trade. Think of the drug trafficking. Think how easy it is just to bung 50 people in a crate that's been kidnapped on a ship in Cape Town, destination China. There are reasons why China and Russia are high-risk countries, and we will explain all of that in the next webinar, where we deal specifically with the risk criteria to which businesses are exposed in South Africa.
Okay, super, Melanie. So, I mean, there were actually quite a number of questions that related to that. The one was actually sort of the Russia-China question, and which other countries or sources are on those specific lists. And then another question is, where does similar to this question really is, where does the FIC or the CDD actually stop? The question came, and I'm going to mention the the entity, and it's not a familiar global entity like Samsung, argument's sake. So you're doing a transaction with Samsung. Where do you stop? Only as far as their activities are in this country, or where does your investigation end?
You've got to create your criteria. So you've got to go and create it. You've got to say Samsung is a multinational global enterprise. Samsung's head office is a subsidiary of Samsung Japan. You've got to go and write those rules into your policy so that when you're dealing with a multinational company, everybody in your office knows what to do. When you're dealing with a South African-based country who exports things, I have a lot of mines that I help. So mines are situated in South Africa, but they export their goods cross-border because it's minerals that they forward sell, like farmers, like miners. We create their rules. We create the rules in the policy.
Okay, that's lovely. Down the absolute other end of the spectrum, where you've got your multinationals that we've just been speaking about now, the other end of the spectrum where you're dealing with a deceased estate and you've got beneficiaries that are people of straw or maybe even struggle to locate their own identity documents and the like. Is that also just a policy question on what steps you do to positively identify them?
That's why we have the different layers of client due diligence, because we have to subject all our clients to our basic client due diligence.
Yeah.
And then we look at the information that we've gathered when completing the basic client due diligence. Then we decide, is this estate, is there anything suspicious here, and do we need to go further in our investigation? So someone in the office will be appointed in the policy to do that assessment. If we decide, because it's people of straw and there really isn't much risk, there's no risk, we say, no, we don't have to apply additional or enhanced CDD. That's the end of our FICA. We close the FICA flimsy, we carry on with the estate, and that is it. So those are the steps we've got to create. Otherwise, we would never get to a point where we sit and assess the information and decide, oh gosh, this is where we need enhanced CDD. This is where, so you've got to create that picture, like a little picture in your policy. So every secretary knows if it's an estate where the heirs are, minor, then we don't need to do enhanced CDD because there's no risk. If it's an estate where most of the heirs are situated overseas, then we have to do enhanced CDD. Those are the rules we've got to create for your business. Otherwise, you'll get nowhere. Otherwise, you'll just be paralyzed like we are now.
Yeah.
We don't know what to do.
Yeah. Gosh, Melania, there are a myriad of questions, but we will collate them all. And I think we are out of time. It's still 13:30. Is that what I could carry on speaking now, and I see there's still a lot of people in the room, but regrettably we are out of time. But I just want to thank you again, Melania. I think it was like super informative. But for everyone who asked the questions, and even those who didn't, please jot down Melania's details that you can see on the screen there in front of you. LexisNexis, you can get hold of us. Together between ourselves and Melania, we help you formulate the policies, we help you with your RMCP, we help you with the KYC. A lot of questions have come up on the list about where do we find help, how can we get help, how much does it cost, do we give the training on the software? The answer to all those questions is yes, yes, and yes, we can help you. Please reach out and we can help you. I think on that note, Melania, I think we've got to wrap it up. I think I've made my point to say to everybody, those that completed the poll, which popped up, thank you very much for that. And Melania, again, thank you very much. And there is another webinar. It's imminent. Please watch the press for details, the social media where the publications are. You probably are on the mailing lists now as well. You will get notifications of the next webinar, and then we will see you there. Again, just to emphasize, we will distribute the recording or the link to the recording of this webinar to all the attendees, all 503 of you that were here today. That includes me and Melania as part of the 503. On that note, everybody, thank you so much. Enjoy the rest of your afternoon and stay focused on the FICA. Thank you very much indeed. Thanks, Milani.
Bye, everyone.
Bye-bye.